The next element of the equation is, once you have decided that, number one, you have an employer who's in Schedule 1, you have a worker of an employer who's in Schedule 1, you have to look at that third piece of the puzzle. Was the injury in the course of that worker's employment? And work-relatedness here is the issue. Now, the Workplace Safety and Insurance Board has written policies about various situations and whether the board considers those situations to fall within the scope of coverage. Those policies, however, are not binding on the tribunal in a Section 31 right to sue application, a Section 31 application. But they are very influential on the tribunal, and they will be part of every written decision. So what do those policies say? The board's policy says that generally, once a worker enters into the employer's workplace, the things that they do there will be held to be work-related unless the facts show that that activity was purely a personal activity. And remember that the employer's premises can include the exterior of the building. So the board's policy says that if the employer owns or controls the parking lot outside of the building, that workers are on the employer's premises when they get out of their car in the parking lot. Another general principle in the policies is that traveling from home to work and back is not a work activity. Of course, there are some exceptions to that general rule. One of the exceptions is if you are being driven in your employer's vehicle or vehicle that is being controlled by the employer. Another example would be an on-call employee who has to respond from home when called out, especially if the employer has supplied a vehicle to do that. Another example is situations where the employee is paid to travel back and forth. There are some factual situations, however, where an employee of a Schedule 1 employer who's hurt at work can still choose to say, I want to sue that other Schedule 1 employer who's caused my injury, instead of claiming WSIB benefits. The situations where this can happen are fairly limited. The most common of these is a situation where the proposed defendant employer, who would otherwise be exempt because they're in Schedule 1, has supplied a motor vehicle, or has supplied equipment, or has supplied machinery on a sale or a rental basis without an operator. That's the important part, without an operator. So, for example, a worker is operating a forklift at his employer's job site, and the employer has leased that forklift from someone else. The forklift has a defect, causes an injury. That worker is entitled to claim WSIB. They're on the employer's premises, they're doing a work-related task, and they're hurt. But they will be given an election form by the WSIB advising them that they may have the right to sue and telling them they must make an election, they must make a choice before they will begin receiving benefits. And that arises out of Section 28.4 of the Act. The other situation that occur is, of course, where a potential defendant is outside of Ontario. The worker would be allowed to choose to sue that person because they're not part of the WSIB system at all. Or another situation may be where the employer has been found to not be in the course of their industry. There is an old case out there about a garage door manufacturer who sells a door. The door gets installed. Years later, it falls on someone because it had a manufacturing defect. And there are tribunal decisions would go both ways, but they're looking at remoteness and saying, is there something which has broken that chain of employment nexus, and therefore it's not, the Schedule 1 employer was no longer really in the course of their industry and therefore not immune from suit.